Hi, my name is Faith Nori. I'm an attorney. I practice in Huntington Beach, California. I practice family law and immigration, US and Canada. I'm also a collaborative divorce attorney and mediator. Today I want to talk about collaborative divorce, how to resolve your dispute through collaborative divorce. Actually, this collaboration can be used in any kind of dispute, but because the system, the idea, the mechanics that has been set is a very good idea in which parties sit together, mediate, and get to terms. But they also have their own attorneys to represent them and be able to negotiate and reach an amicable resolution. So the way collaborative divorce works is that parties will require to find attorneys who are trained in collaborative divorce, because not all are. Maybe 1% of divorce attorneys are collaborative divorce attorneys. And then once you find an attorney that is trained in that area and you are comfortable with them, then you will be able to seek their assistance to assist you in resolving your dispute and reaching an amicable resolution in your post-separation matter. So a collaborative divorce attorney will assist in preparing all your paperwork and getting them all in compliance with the court. So when you get a mediator, really the mediator's role is not to do that, to prepare paperwork, because divorce require, basically parties are on two separate sides, so they are in conflict with one another. Why? Because their interest is not the same. And that, why is that? Because that's how we all think, that my interest, it's my interest, your interest is your interest, and it doesn't get mixed up. Of course, changing that mentality and being fair to both sides is a process, but in explaining methods of resolving your dispute, State Bar of California had made sure that a mediator does not represent parties in a matter. Basically, is a neutral third party who's resolving a dispute. So collaborative divorce attorneys are actually representing a party. So let's say I get hired to represent a party, and I will assist that party in resolving their dispute. In doing that, I will advise my client what is the law if she asks me or he asks me, and I will explain what are the ramifications of accepting this term or that terms. Of course, the setting is a mediation setting, meaning that the idea is for parties to settle. So when the parties agree to enter into a collaborative divorce, they understand that if they actually step away and say, you know what, I changed my mind and I no longer want to do resolve this in this way. I want to go to court and I want to fight. Well, all the efforts they put in and also the money that they spend on their attorneys to do the collaboration is lost. So that's why there is an incentive for parties to continue in this method. If there are any domestic violence issues, usually mediation is not a great idea at all to enter into by the parties. So the collaborative divorce could be a good idea because you have an attorney who represents you. Again, if there is too much disparity or imbalance of power, it may not work, and maybe, again, other options that are available can be utilized. But I think even in that scenario, you can resolve disputes by making sure, again, setting the stage in such a way that parties can understand what they are doing and how they can accomplish their goals if they actually learn to work with each other. So in a collaborative divorce, a lot of times there are many issues that may not be resolved through because attorneys do not have access on information through their meetings. So let's say you have a party who is, has this belief that the other party is unable to care for the children or child during their custodial time or proposed custodial time. Well, in that sense, it may be an idea to engage somebody who is a psychologist, and it seems like it's very similar to co-mediation, but basically you engage them to come into this structure of collaboration and try to assist the parties as to what works for them. So what is your schedule? What are the issues? What are the misgivings that the parties have? And that's how you resolve a dispute. If in fact the parties are not able to talk to communicate with each other, then again that manager, family therapist, or a person who has training to deal with parties' emotional issues will bring them, to sit down and discuss their problems either together or separately, and then she would communicate with both of them as to what she has heard or he has heard, and basically bring them closer together. Sometimes children are of the age that they can express what they desire, so then the next step is to discuss it maybe with a child psychologist or a child therapist who can express and speak with the children or child, and finding out what do they want. Do they want to spend time with mom or dad, and why is that? Of course, children can be influenced during divorce and separation. A lot of times there's, what we call alienation, although it's not a technical term, but that could happen. At times, parties, talk badly about the other parent or partner. So it could affect the children, and it does. So it is incumbent upon the person who's speaking with them to try to bring that out and let them know that it happens to now many families, and we understand divided loyalty, and that what they may hear from one parent against the other parent doesn't necessarily mean that it is the truth of what is happening or happened, and it's just a perception, and they need to look at it as they are going through the process, and they both love their children, or child. So, and that has to be emphasized. So basically we start using other experts. So if there's a financial issues that would require a forensic accountant, it will be invited in to be a joint person to go over the paperwork and find out what are the issues as to finances, what are the items that one party feels that is not being disclosed, or it's not truthfully provided to the other party as to documents that has to be exchanged, because in the divorce proceedings, party is supposed to exchange documents. So if there are anything that one party feels that is not done properly, through an expert we could get that done. I'm not talking about discovery, trying to obtain a document. So I'm talking about reading between the lines and see, for instance, what is the cash flow, what's the income, things like that. Especially if a person is not a W-2, because W-2 you can easily find out how much their income is. But if they have their own business or self-employed, they have a corporation, and things can be hidden through the corporation. So collaborative divorce basically will do what you need to or you want to accomplish, but without the necessity to go to the court proceedings. So meaning that you can reach all the items, look at all the assets and debts, get them all divided equally, equitably, and you can sometimes it may not be equally, but is equitable, and you can reach agreements as to custody, as to support, all of them through that setting. The question that I sometimes hear from parties is that, well, this is not equitable, this is not fair. Well, fairness is really subjective as to what we perceive it to be. So if a party had a property prior, or had a bank account prior, and then prior to the relationship, and then after the relationship, let's say the money was used for down payment of the home or for other expenses that is traceable, it is not fair for the other party to lose their assets or their separate property once they engage into the relationship. So fairness is really a perception of how a person sees that and relate to that. So yes, we need to take all those into account. That said, this is one of the segments that I'm talking about collaborative divorce, and I will discuss this further in another segment as to what to be aware during a collaborative divorce, and how maximize and benefit from this process. It was very nice talking to you today. Thank you. Have a good day. Bye-bye.